The matter is here today after a hearing that lasted most of the day with regard to the petition for supervised release that was filed earlier this year. It was filed on October 11, 2024, and then the doctor's reports were received, and we had each of the doctors testify. So the reports that the court received were from Dr. Collins. With regard to her report, she testified. With regard to Dr. Lundbone, she testified as well as her report. And from Dr. Robbins, who testified, and we have his report. All of the reports were received without objection from any of the parties, and the testimony came in smoothly. What's the nature of I went through at the beginning of the hearing this morning what the status of the initial case is from the standpoint of how it came about back in 2014. We're familiar with that set of facts. What the court has to do today is that the court shall grant the petition for release unless it finds by clear and convincing evidence that the person poses a significant risk of bodily harm to herself or bodily harm to herself or to others, or of serious property damage if released. What that sentence takes into account is that the issues of supervised release and not guilty by reason of mental disease or defect takes into account a lot of cases. That we're dealing with an attempted murder case in this matter, but it takes into account many other cases and outstanding criminal matters that are out there that involve property damage, don't involve people at all. So that's why the statute's phrased the way it is. But our focus is on on risks of safety to Ms. Geyser herself or the risk to others. And part of that risk is, of course, recidivism, that it happened once, would it happen again, that she'd attempt to kill somebody under any set of circumstances. Those are factors that the court has to look at and decide. Burden is on the state by clear and convincing evidence to establish that the current restrictions and the current commitment should stay in effect. By statute, Ms. Geyser has a right to file for a petition for release every 6 months. So it's not something that, with regard to what the court may or may not do today, if the court denies the petition today, she can come back and file it again in 6 months. That doesn't mean anything other than that. It's just what the law is. Some of it may have been to address constitutional issues with regard to commitments, but it's certainly part of the system. One thing to keep in mind as well, and that this was a serious criminal case, attempted murder. There are two defendants in the case. Both were children at the time that it happened, 12 years old. The victim was a child. But the case didn't resolve itself per se in the criminal field. It's not a criminal conviction. In this case, based upon the nature of the law and what happened, the court found that Ms. Geyser was not guilty by reason of mental disease or defect. Then that moves it into the commitment field, the civil field that we're addressing today under Chapter 971, in particular 971-17 of the Wisconsin statutes. So this isn't about somebody going to prison. It's about somebody being committed to a mental institution, to a hospital, and how that person functions within with that institutional setting. In the statute 971-17 sub 4 sub D provides some factors for the court to look at in deciding how best to look at what the issues are. Factors the court can consider are the nature and circumstances of the crime, the person's mental history, Ms. Geyser's mental history, what her present mental condition is. We've had a lot of testimony about that and a lot of reports written on that topic. Where will she live, what the status is, how the person would support herself, what arrangements are available to ensure that she will have access to and take necessary medications, and what arrangements are possible for treatment other than medications. So some of those factors are clearly pertain to the case, some don't. But I'm going to talk about a number of them as I see the reports and what happened in this matter. A further comment for the court to keep in mind, and it was really addressed as part of the argument that Attorney Cotton brought forward, and that was the issues in State versus Randall. That was the Court of Appeals decision that was referenced during his argument, and actually referenced by the state at various times as well. In the Randall case, and it's just a 2011 WISAP 102. It's a 2011 Court of Appeals decision. As was noted, Randall is a case that arose out of Waukesha County. It's a Waukesha County case. One of the officers, the wife of one of the officers who was killed, worked here at the courthouse. So it is a case that has deep, if you will, deep roots into the Waukesha County legal system. But it's now somewhat of the stellar case, the keystone case, and looking at issues such as this. But the Attorney Cotton contrasted the conduct of Mr. Randall in all of his situations with Ms. Geyser's conduct, and I think that's a relevant analysis for the court to have heard and for the court to consider. There is a difference between how Randall conducted himself and how Ms. Geyser has conducted herself during the time period that she's been in custody. One of the aspects of the case, and it's apparent, but yet it somewhat needs to be restated, is that the offense in this matter occurred when the defendants and the victim were children. They were 12 years old. The adult offense, no doubt, but still it happened when they were children. It's happened in 2014. It's about, 10 and a half years, a little more than 10 and a half years from the date of the incident. So the victim has grown up, the defendants have grown up, things have changed from the standpoint of the chronology and age of the parties. In cases such as this, we never want to lose contact and forget the victim that's involved. This is a terrible, brutal offense. There's no doubt about it. It's a nasty set of situations. I went back, and at the time that the court made its initial decision of commitment, the parents of both the father and the daughter of the victim wrote letters to the court that described the status, basically, of what was in existence in February of 2018 with regard to their daughter. And those type of factors are still clear today. It's 10 years later, but I'm sure that the impact on the victim, on her family, and on everybody involved in the case is still very apparent and real. So we want to be sure the court keeps that in mind in deciding how best to proceed. There's been a lot of discussion in the case. In fact, it's a critical part of really understanding and analyzing what's happened in the matter, is that the matter was originally came about with the diagnosis of schizophrenia, and there was a lot of discussion at the time of the initial hearings, childhood, schizophrenia is an unusual diagnosis, not common, still not common today, but it still is one that existed, was made, and was clarified and established at the time of the hearing. That was the diagnosis that brought about actually the plea of not guilty by reason of mental disease or defect in the court's ultimate findings. There have been changes in from the Ms. Geyser's standpoint and how she's explained what happened. And that comes into whether the Slender Man, the hallucinations and all that went on with that actually happened, or did she make them up? That's been part of the testimony going back to 2021 and 2022. I'm satisfied that those change in views and circumstances existed, but I'm also satisfied that the treating, and I'm talking about the treating doctors, not the examining doctors, that I'm satisfied that the treating doctors have addressed that issue and have worked with her with regard to that. I'm satisfied that the examining doctors, Dr. Collins, Lundbaum, and Robbins, all address those matters as well. And I'm satisfied through the manner in which they've addressed Ms. Geyser's change in position, if you will, or modification of position is something that's can be reasonably explained under the circumstances. I don't find that she was, from the standpoint, attempting to fabricate a position to get a more favorable position with the court. Now, I raised that issue with Dr. Lundbaum as I wanted to hear what she had to say specifically about that. But I'm satisfied that that is not a factor that I'm considering in deciding how to proceed. I am considering that the diagnosis develops over time, as it does with many people, and I accept Dr. Lundbaum's statements that because of the nature of childhood schizophrenia, it's the nature of the diagnosis, the nature of its history, that it would develop and change over time is not unusual. I accept that. I didn't question it was my questions that brought it up with Dr. Lundbaum. I didn't question Dr. Collins or Dr. Robbins about that topic. I was satisfied with what Dr. Lundbaum said with regard to that status, and I'm still satisfied with that. I'm satisfied that one of the interesting, at least I find it interesting and significant with regard to what's gone on in this case and apparently other cases, is that if you're at Winnebago and in a treatment program for a serious offense such as this, Winnebago will only take you so far. And at a certain point, they won't take you any further. Now, it surprised me when this first came up earlier in the case, that I would have thought that the state institution would carry on the treatment and take it to its fullest extent. Whatever the next step is, they would take the next step from the standpoint of improving the mental health of the patient at a minimum, as opposed to public safety, but that's not what they do. At the stage that Ms. Geyser is at, she can't go any further as far as treatment is concerned. And keep in mind that as far as being able to walk around and do stuff, she can walk around at the institution, but if she goes off institution, she always has somebody there, so an escort. Now, to me, in order to be able to really adequately be, if you will, to the extent somebody can be rehabilitated, they have to be able to exist in the community somehow and be able to grow up, if you will. And that isn't going to happen with regard to Ms. Geyser at the Winnebago Mental Health Institute. That's a factor. I don't want to say it's determinative of the decision I've reached, but it's a factor that I've considered as to public safety is really the underlying key to the case, and part of public safety is that Ms. Geyser becomes safe or safer. That was clear in the analysis from the Randall case. It's public safety is tied into the safety of the defendant, of the patient. In Randall, it's clear that Randall never was able, I don't know what his status is currently. He's still in custody. He's still within the program, but that he's never developed that sense when people trust him to be safe, and that's the people that treat him. And that was back in 2011. I'm assuming it's still the case today. That's the factor that I looked at in contrasting Ms. Geyser's situation with Mr. Randall's situation. I looked at Ms. Geyser's, her role in working through treatment and supervision at Winnebago, and find that I'm satisfied she's done what she's supposed to do. She appears to have a good attitude. Attitude is important. It doesn't solve all issues, but it's certainly an important part of being able to be rehabilitated and being able to function within the community. Because although we focus on public safety and whether she continues to be a danger, part of that is if, in theory, she would be released at some point, she has to be able to function within the community on a safe basis, and people, while she may always be subject to some type of notoriety, there she is, that type of thing, like the scarlet letter almost. And but that there has to be, people have to be able to relax and know that if she walks past them on the street that they're safe. That's what the safety evaluation is, the risk to dangerousness is about in the case, as far as I read it, as far as I read what the statute's concerned. That's because, especially with regard to looking at the Randall rationale, Randall stands for the proposition that I can ignore all of the reports and I can find that she's dangerous simply based upon what happened on May 31, 2014, because of the nature of the offense and the nature of what happened. That's, if I can make a decision simply upon that. I'm concerned about making a decision simply upon that because it somewhat flies in the face of what the evidence is with regard to Ms. Geyser's treatment program or regimen, and what I'll phrase it as her success at being treated at the Winnebago Mental Health Institute. One of the activities I engaged in when I took the break was to read my decision from April 11, 2024. I had not read it before. Attorneys at Packowitz referenced it, so I thought I should go back and read what I said back then. And my comments with regard to the nature of the case still to a great extent stand true at this point. However, there have been changes in the case and how I view it based upon what's been presented. And I do rely to some extent upon the reports of Drs. Lundholm and Collins. Dr. Robbins writes a good report, but it's a brief report, and it's almost a flow of consciousness of how he views the case based upon his involvement. Drs. Lundholm and Collins go into more, if you will, more depth, more nitty-gritty of what the situation is and how things developed, how attitudes developed, and what the status of the matter is today. So when I read that and read those reports, it gives me a further insight into what the status is of Ms. Geyser's status with regard to the case. What the record shows that she's done well. She's hasn't had rule violations. Laws are always about rules. Lawyers are always about rules. Courts are about rules. And she's followed the rules. She's done well. Good, I mentioned attitude, positive attitude. Those are all good things to have. Does that overcome what happened back in 2014? It may never overcome what happened in 2014. But the question isn't about what happened in 2014. It's about current assessments of dangerousness to herself, to the public, or a danger to the destruction of property. In evaluating the matter, I take into account, as I indicated at the beginning of my decision, that she's been in custody since she was 12 years old. She's gone through a number of evaluations and treatments. That each one of I think both Dr. Lundbohm and Dr. Collins refer to all of the reports that they looked at. That doesn't always count all of the doctor notes that are involved at Winnebago. To a great extent, the November 7, 2024 letter that was signed by Ms. Parnell summarizes all of those medical records and notes and doctors' notes and observations with regard to Ms. Geyser. So I take that into account in deciding how best to approach the case. The aspect of dangerousness is difficult because we never know. I mean, I could claim to be the smartest person in the world and make decisions, and I don't know what's going to happen with regard to this case or many other cases, or what's going to happen tomorrow with regard to my cold. You just simply don't know. So you have to be cognizant of the if you will, the fragileness of the type of decisions that the court makes and that the court looks at. I note that in Dr. Collins' decision, on she wrote a long report. 37 pages, single-spaced paragraphs, so it's easier to read. But on page 37 of her report, in the second paragraph, and I think Attorney Zapakowicz referred to this during his argument, I'm quoting now, while it is this examiner's opinion to a reasonable degree of professional certainty that facts weigh in favor of Ms. Geyser's petition and placement on conditional release at this juncture, I also recognize considerations which may give pause. The issue of Ms. Geyser's diagnosis enigma is one such consideration. Ms. Geyser now reports that she's never experienced auditory hallucinations or psychotic symptoms otherwise. The etiology of her historic psychotic symptoms remains unclear, especially in light of the fact that she has not been prescribed antipsychotic medication in recent years and has nevertheless not evidently demonstrated a reoccurrence of psychotic symptoms. She warrants ongoing close clinical monitoring and treatment, in part to support her transition to the community through, as importantly, to effectively and efficiently determine and respond in the event of any reoccurrence of symptoms of a major mental illness. I read that paragraph in full because that's an important consideration, and it caused the court pause with regard to how to evaluate circumstances. However, when I read the entire report by Dr. Collins and Dr. Lundbohm, as well as what they testified to, I'm satisfied that those are caveats for the court to be concerned with and to evaluate in a way with regard to the issue of dangerousness. It's not necessarily a veto over the release on a supervised release petition. So in reviewing all of the reports and the matters, I'm satisfied that under the circumstances that the court's going to grant the release. I'm satisfied that by clear and convincing evidence that Under the current set of circumstances, Ms. Geyser does not pose a significant risk of bodily harm to herself or others, or of serious property damage. Now, when I make that finding, I take into account what happened. I take into account the dangerousness of what happened back in 2014. I take into account, though, what's happened since then, in particular in the last 6 months. I take into account the opinions of the doctors, but in particular, and it's been an important analysis for the court to make, that as the Randall decision talks about, that the ultimate determination of dangerousness requires a careful balancing of society's interest in protection from harmful conduct against the acquittee's interest in personal liberty and autonomy. In looking at the Randall case and of what happened in Randall and what the circumstances were of Randall, when I contrast Randall to Geyser, there's a tremendous difference in the rationale for rejecting supervised release in that case, in Randall's case versus in this matter. When I weigh that dangerousness concept and I come back to what happened and what the progress has been, Ms. Geyser doesn't fall into the same category as Mr. Randall in his petition for release and the denial of that release. So on that standpoint, I'll grant the petition so ordered. I'll order that the matter be referred to the department. And let me just look at the statute. 971-17-4E. If the court finds the person is appropriate for the conditional release, the court shall notify the Department of Health Services. The Department of Health Services and the County Department in Waukesha County shall prepare a plan that identifies the treatment and services, if any, that the person will receive in the community. The plan shall address the person's needs, if any, for supervision, medication, community support, residential services, vocational services, and alcohol or other drug abuse. The plan shall be presented to the court for approval within 60 days after the court's finding that the person is appropriate for conditional release. Dr. Lundholm, in her report, and I think it's begins on page 15. That begins on page 16 through 17, lists 11 factors that she'd want considered. And I want those all considered by the department as they determine, excuse me, as they determine what the conditional release plan should be. Excuse me, let me just have a moment. In this area, I took into account Mr. Attorney Zapakowitz's argument about what do we know about the future. Well, the way the statute's set up, as I read it, is that the future is determined by the release plan. We only get to the release plan, excuse me, if the court grants the release. For the reasons stated, I've granted it. I'm satisfied now that the fleshing out of what that means, supervised group home, group facilities, that Dr. Robbins discussed and what Dr. Collins discussed as well, are now subject to the state and further subject to my approval when it comes back. So although I grant the supervised release, I did take into account the argument that Attorney Zapakowitz made with regard to what's known and unknown. I'm satisfied that the system we operate under 971-17 takes that into mind and encompasses it in and the work that the county, that the State Department does with the county. On that basis, then we'll schedule a hearing within 60 days. My anticipation is that the report from the state, the conditional release plan, will be submitted before then.
Right.
So what I'm going to look is to have let's schedule a hearing within 60 days.
How much time do we need for the hearing?
I'd say an hour. We'll just move other things, just fit it in.
February 20th, too soon?
Excuse me, my coughing here. I want to be sure the report comes in. 60 days would take us to about March 9th. That's maybe at the end of February. Look to have the report submitted within, say, a month of today, supervised release plan within a month, by the beginning of February 9th or 10th.
I have March 3rd at 9 o'clock.
Should we go for that?
I can make that work. I was going to suggest that Friday that week, if that's available for everybody, but I can be flexible.
The 3rd is good for me, better than the 6th or 7th.
Okay, let's just do the 3rd in the morning.
Attorney Nicolai?
That's fine. The 3rd is fine.
Okay, 9 o'clock?
Sure.
March 3rd at 9 o'clock.
Oh, so I'm anticipating that we'd have the proposed conditional release plan by, I'll say by February 14th. Now that may change, the state will do what they have to do, but I want to be sure we have plenty of time to evaluate it. With that, then, Ms. Geyser will be remanded to the sheriff to be returned to the Winnebago Mental Health Institute.
Thank you.
So ordered.
I'll be in touch.
Court will be in recess.